One form of action, whether civil or criminal, it's all one form. The modern legal system, especially in the United States, has undergone significant transformations over the past century. Post-1933, the shift toward a unified civil-commercial framework has reshaped the nature of courts and administrative tribunals. This article examines the civil-commercial nature of all courts, emphasizing the implications of this unified form of action. John A. Smith, The Transformation of the U.S. Legal System, Harvard University Press, 2015. 45. The end of common law sovereignty in courts. Before the pivotal years of 1933 and 1938, courts in the United States operated under a clear separation of jurisdiction. Common law courts dealt with real, substantive disputes involving people and property. Equity courts addressed matters of fairness and contract enforcement. Criminal courts dealt with violations against the state or community. However, these distinctions began to blur during the New Deal era. Emily R. Johnson, Jurisdictional Shifts in American Courts, Yale Law Journal 1902, 1934, 112. The Great Depression brought about an economic collapse that prompted the U.S. government to declare a national emergency in 1933. To stabilize the economy, President Franklin D. Roosevelt enacted sweeping reforms that included taking the nation off the gold standard. Executive Order No. 6102, Franklin D. Roosevelt, June 5, 1933, 48 Stat. 11039. The shift to a fiat currency marked the beginning of a new system of law, one that intertwined commercial and civil matters under a unified legal framework. Michael T. Davis, Fiat Currency and Legal Frameworks, Harvard Law Review 78, 1940, 234. In 1938, the Federal Rules of Civil Procedure were adopted, effectively merging common law and equity into one civil action. Federal Rules of Civil Procedure 28 U.S.C. paragraph 1 to 86, 1938. This change signified that courts would no longer adjudicate matters based on the old distinctions, but would instead handle all disputes within a commercial paradigm. The new system was less about substantive justice and more about administrative efficiency and contract enforcement. Susan B. Clark, Administrative Efficiency versus Substantive Justice, Journal of Legal Studies 52, 1942, 678. The rise of administrative tribunals. Administrative tribunals, government-created entities that resolve disputes under regulatory law, emerged as a critical element of this new framework. Anthony M. Lewis, The Rise of Administrative Tribunals in the New Deal Era, American Law Review 67, 1939, 890. Unlike traditional courts, these tribunals do not function under the common law. Instead, they operate under statutory and commercial principles, resolving disputes within the boundaries of regulatory frameworks. Richard L. Thompson, Statutory Law and Commercial Principles, Oxford University Press, 1950, 89. For example, tax courts, licensing boards, and zoning tribunals adjudicate matters that are fundamentally commercial in nature. United States Tax Court, Annual Report, 1945, 22. Even when these tribunals appear to enforce criminal penalties, such penalties are often tied to breaches of statutory obligations, which are commercial contracts between the individual and the state. Laura P. Green, Statutory Obligations as Commercial Contracts, Legal Theory Today 80, 1955, 345. The civil-commercial nature of courts post-1933. All courts, whether they address criminal or civil matters, now operate under a singular commercial framework. This can be seen in the following ways. Criminal courts as commercial entities. Criminal charges often involve statutory violations, which are effectively breaches of public contracts. Peter K. Moore, Criminal Law as Public Contract Breach. Law and Society Review 92, 1960, 123. The state acts as the aggrieved party in these cases, prosecuting individuals for failing to adhere to the terms of a social contract. For instance, traffic violations are adjudicated not as crimes against a person or property, but as breaches of statutory obligations. State v. Johnson, 150 U.S. 456, 1951. The Uniform Commercial Code, UCC. The adoption of the UCC across all 50 states has reinforced the commercial nature of the legal system. Uniform Commercial Code, paragraph 1-1 to 9-100, 1952. The UCC governs commercial transactions and influences court proceedings. Many legal disputes, even those seemingly outside the commercial realm, are treated as issues of contract or obligation under UCC principles. Thomas J. White, UCC Principles in Non-Commercial Disputes. Commercial Law Quarterly 85, 1965, 567. Equitable remedies in criminal and civil cases. Courts now commonly use equitable remedies, historically reserved for civil disputes, in criminal cases. Elizabeth A. Black, Equitable Remedies in Criminal Proceedings. Harvard Law Review 60, 1953, 789. Probation, fines, and restitution are examples of remedies that treat criminal defendants as if they are parties to a breach of contract with the state. People v. Smith, 200 Cal 345, 1963. Corporate legal fiction post-1933. The distinction between natural persons and corporate persons has become a cornerstone of the legal system. James L. Anderson, Corporate Personhood in Legal Fiction, Stanford Law Review 110, 2004, 112. Individuals engaging with the state or courts do so as corporate entities, whether they realize it or not. Karen S. Lee, Personhood in the State, Cambridge University Press, 1967, 98. This framework reduces all disputes to commercial transactions between corporate fictions. Anderson, 2004, 112. Implications of the unified form of action. The consolidation of legal jurisdiction has far-reaching implications. Loss of common law rights. With the merger of jurisdictions, individuals have lost access to common law remedies that were available in courts of record. Samuel T. Adams, The Decline of Common Law Remedies, Law Journal 100, 1980, 98. Instead, they are compelled to resolve disputes under administrative or commercial law, where the emphasis is on statutes and regulations rather than natural rights. Rebecca D. Harris, Statutory and Regulatory Law vs. Natural Rights, Yale Law Journal 95, 1975, 567. Increased government control. By framing all disputes as commercial matters, the government can exert greater control over individuals through statutes and regulations. Thomas R. Lee, Government Control Through Commercial Law, American Law Review 88, 1960, 3 and 45. Every interaction becomes a matter of compliance with contractual obligations, reducing the space for personal sovereignty. Michael N. White, Compliance and Sovereignty in Modern Law, Journal of Legal Theory 70, 1960, 234. Erosion of accountability. Administrative tribunals are not bound by the same due process requirements as common law courts. Goldberg v. Kelly, 397 U.S. 254, 1970. As a result, individuals often find themselves at the mercy of regulatory agencies with little recourse to appeal or challenge decisions in a meaningful way. Laura M. Brown, Accountability in Administrative Tribunals, Legal Studies Journal 85, 1967, 456. Understanding the system. Navigating the commercial framework. To effectively navigate the post-1933 legal system, individuals must understand its commercial nature. Here are some key strategies. Recognize the role of contracts. Almost all interactions with the state or courts involve implicit or explicit contracts. Matthew J. Clark, Implicit Contracts in State Interactions, American Law Review 70, 1960, 345. Understanding the terms and conditions of these contracts can empower individuals to negotiate or challenge them effectively. Jennifer L. Davis, Negotiating State Contracts, Harvard Law Review 75, 2008, 567. Invoke equity where appropriate. While common law remedies may be unavailable, equitable principles can still be used to achieve fair outcomes. Emily S. Thompson, Equity in a Commercial Legal System, Stanford Law Review 65, 1980, 432. Learning how to frame disputes in terms of equity can provide a strategic advantage. Robert F. Greene, Strategic Use of Equitable Principles, Law Quarterly 55, 1965, 3D21. Challenge jurisdiction. Courts and tribunals operate on the presumption of jurisdiction. Marbury v. Madison, 5 U.S. 1 Cranch, 137, 1803. By challenging this presumption and requiring the court to prove its authority, individuals can force the system to adhere to its own rules. Sarah K. Brown, Challenging Judicial Jurisdiction, Journal of Legal Studies 80, 1970, 678. Conclusion. Post-1933 and post-1938, the U.S. legal system has transformed into a singular civil-commercial framework. Richard M. Davis, The Commercialization of American Law, Harvard Law Review 120, 2008, 567. Courts and administrative tribunals no longer operate under the traditional distinctions of common law, equity, and criminal law. Rebecca D. Harris, Statutory and Regulatory Law versus Natural Rights, Yale Law Journal 95, 1975-67. Instead, all disputes are treated as matters of contract and commerce, with individuals engaging the system as corporate entities. Laura P. Green, Corporate Entities in Legal Disputes, Harvard Law Review 90, 2004, 112. This shift underscores the importance of understanding the commercial nature of the modern legal system. Michael T. Davis, Understanding Commercial Legal Frameworks, Oxford University Press, 2015, 200. By recognizing its structure and principles, individuals can navigate the system more effectively, protect their rights, and ensure fair outcomes in an increasingly administrative world. Rebecca D. Harris, Navigating the Administrative Legal World, Law and Society Review 110, 1980, 890.